Welcome back, future lawyers, to another video. Today we're going to be discussing the intentional tort of false imprisonment. So let's just dive right in. False imprisonment has three essential elements, but just like the other intentional torts that we discussed this far, we're always going to start with those two prerequisites. If you guys can't remember what those are, go back and watch our previous videos. We need an act, so a defendant acts, and remember that is a voluntary act with the intent. How do we describe intent? If you said purpose or knowledge to a substantial certainty, you are 100% correct. To confine or restrain. And the second part of that is a plaintiff to a bounded area. And so you want to think of these two elements kind of like a sentence broken up into clauses. So think of it as being a comma right here. And we're going to evaluate this in two parts. So defendant acts with intent. So to confine or restrain, what does that mean? There are four different ways that we commonly see confinement and restraints being defined when we're dealing with false imprisonment. Guys, have your torts notebook. This is written out and outlined in there for you. Grab it and you can write in some extra notes. If you don't have a torts notebook, find a piece of paper and write this down. The first one being a physical barrier, and that's the most obvious, right? If I lock you in a room and throw away the key, you're confined by the four walls of that room. If I handcuff you, if I hog tie, then that's another example of a physical barrier. Physical force or threats of force. If I sit you down in a chair and I say, if you take one move from that chair, I'm going to punch your teeth out, that is a threat of physical force. If you try to get up from that chair, if you try to stand up and I automatically push you down and say, no, you're going to sit there, that's physical force. The third way we can define confinement or restraint is by failure to release or let out. Let's say you meet a Tinder date online, you go over their house, they lock you in their house and they say that you can't leave. You can go about the house, but you cannot leave this property. You are going to be mine forever and ever. That is an example of false imprisonment. And then there's invalid use of legal authority. If I exchange words with a lady at the grocery store and she tells me, you know what, by the way, I'm a police officer and I'm going to arrest you and put you under arrest because I don't like how you talk to me, that can be defined as confinement or restraint. Now, you may think it's pretty obvious that if you're being confined or restrained, then duh, is to a bounded area, right? If I've hog tie you, then you're confined to the space of your body. You can't move. Like, that seems like a no-brainer. So why do we treat that like it's two separate elements? That's because it's important when you're evaluating false imprisonment on your exams and in real life. It's important to notate and to set the stage for what the bounded area might be, because the facts will have to show that there can be no reasonable means of escape for the plaintiff. The way that you want to explain that the plaintiff is confined to a bounded area, you want to show that there's no reasonable means of escape. How do we determine what a reasonable means of escape is? A means of escape is not reasonable if you don't know about it or if it isn't apparent. So back to my hog tie example, if I handcuff your wrists together and I handcuff your ankles together, but you don't know that it's trick handcuffs or just child's handcuffs and all you have to do is a latch, you think that these are real handcuffs for which you need a key because I like dangled a key in front of you like, oh, you're never going to get out of here. But in reality, they're just playful handcuffs. And we still have false imprisonment, right? Because it's not apparent to you that I was just playing. I made you believe that these were real handcuffs of steel, that the only way you can get out of them is if you had a key, that I wanted you to stay here forever. And so that's false imprisonment. When talking about restraining the plaintiff to a bounded area, it is important to note that if escape means are reasonable, then it's not false imprisonment. And if your plaintiff can reasonably escape, then it's not false imprisonment. Another important exam tip to note is that your plaintiff must be aware of the confinement. If you and I are partying and you fall asleep in the bedroom and I lock you in the bedroom because I don't want you to leave, but when I come back in and unlock the bedroom, you're still sleeping, you never woke up in the middle of the night and tried to get out, you don't know what happened, you just wake up and you're just like, oh, I had a good nap, how was your nap? Then that's not false imprisonment. You never knew that you were confined. Even though I was on some questionable behavior, you didn't know that. So when we talk about reasonable escape, let's give a couple examples. If I lock you in the bedroom and there's a fire escape on the bedroom that has stairs, imagine like a New York apartment that has stairs leading down to the ground safely, then that's not false imprisonment because you could reasonably get out. But what if in that same fact pattern, I have metal bars over the window? You can't access the fire escape? Then yes. Then that one little detail, that one little change in detail would make that false imprisonment. Again, when evaluating false imprisonment, there can be no reasonable means of escape. So if the way to get out of escape is embarrassing, hidden, or dangerous, then that's not reasonable. If I lock you in a room and I put the key in a cage full of venomous snakes and I say, well, you have a key, all you gotta do is get to the key, that is dangerous. That's not reasonable. That's not a reasonable means of escape. Let's say we meet on Tinder. I have you come over for a date. We Netflix and chill, and you try to leave the next morning, but I've hidden all of your clothes. But then I say, you're free to walk out the door if you want to. That's not reasonable, because walking out the door will cause you embarrassment and humiliation. You don't have any clothes on. That's false imprisonment. Another exam tip that you want to note is that the imprisonment does not have to be for a lengthy amount of time. It doesn't matter if it's 5 minutes, 5 hours, or 5 days. When you act with the intent to confine or restrain someone to a bounded area and don't leave them any reasonable means of escape, it is false imprisonment, regardless of how long the length of time is. So just to recap the elements of false imprisonment, a defendant acts with the intent to confine or restrain. Don't forget to lay out what that confinement or restraint might look like. Again, it could be physical barriers, physical force or threat of force, a failure to release or let out, or an invalid use of legal authority. And then define the plaintiff to a bounded area. You want to remember, ask yourself why. Why was the plaintiff bounded to a particular area? Were there reasonable means of escape? Ask yourself these common questions. Was escape hidden or was it apparent? Was it dangerous? Was it embarrassing? And remember always when you're evaluating a false imprisonment fact pattern or what might appear to be one, the plaintiff has to be aware of the confinement. There can be no reasonable means of escape and the time period does not matter. Even if the facts say it's just for a minute, a literal minute, false imprisonment is false imprisonment. As always, future lawyers, if you have any questions, drop them in the comments below. Don't forget to like and subscribe. And as always, future lawyers, see you in court.